change. There's a second. All right. All right, let's get started. On behalf of CCN, the Canadian Cybersecurity Network, we welcome everyone. Interestingly enough, during our last monthly survey that we held, we asked our members what they wanted governments in Canada to work on the most urgently. We gave them a whole bunch of subjects, and cyber privacy was number 3. So the first one was cyber employment. The next one was cybersecurity business funding, and the third was privacy. So know that this subject is a very interesting and a very important one for our membership. So great timing for this session. Just before I pass it on, I wanted to say that our next session in May is Boom, Land Your Dream Cybersecurity Job. So you can register for that. I'll put the link in the chat group so that everyone can register. And I'll pass it off to Elise. Thank you. Enjoy.
Thanks, Francois. Just going to share my screen. We'll get started. Now, are you seeing that full screen, David and Vance?
Yes.
Okay, good. Perfect. And I just want to make sure I still have the chat. Well, hello, everyone. It's great to be here. I'm Elise Parr. I'm a program lawyer at Osgood Professional Development, and I work on our continuing legal education offerings in privacy and cybersecurity law at Osgood. So before I introduce our 2 privacy and cybersecurity experts and we start our fireside chat, I'm just going to take a few minutes to tell you a bit more about Osgood Professional Development and some of our programs. So we are the professional development arm of Osgood Hall Law School at York University in Toronto. And Osgood has led some of the most important innovations in Canadian legal education since 1885. So we are an industry leader in this space, and we offer a broad range of both graduate and continuing legal education programs in a wide range of practice areas. And I'm just going to quickly highlight 3 of our programs related to privacy and cybersecurity law. So the first 2 are continuing legal education programs. We have our annual update in privacy and cybersecurity law and practice, which is an intensive 1-day program that focuses on changes in the law and regulations across Canada. We look at hot topics from the past year and practical strategies and best practices for those working in privacy and cybersecurity and for their advisors. Then we have our certificate in privacy and cybersecurity law, which is a more comprehensive 5-day program that combines substantive law, practical skills, interactive discussion, and exercises. And it's led by a diverse faculty of lawyers, academics, and privacy and cybersecurity professionals. And finally, we have a professional LLM in privacy and cybersecurity law, which is a 2-year part-time Masters of Law program. And that provides you with legal expertise and professional skills to navigate evolving privacy protection in the face of emerging technologies and institutional practices. So 3 very different offerings, all within privacy and cybersecurity law. And all of these programs are open to both lawyers and non-legal professionals that work in the privacy and cybersecurity space. And our programs do attract a diverse group of expert faculty and participants. And that really provides a unique opportunity for networking, personal and professional development, no matter which of the 3 options you choose. So we really do try to have something for everyone. Now I'm going to introduce two of our faculty members today. So both David Goodis and Vance Lockton teach on our professional LLM program, as well as in our 5-day certificate. David is a partner at Inklaw, specializing in privacy and access. And previously, he was a senior information and privacy lawyer with Ontario's Information and Privacy Commissioner for over 30 years. And Vance is Senior Technology Policy Advisor for the Office of the Privacy Commissioner of Canada. And he spent 13 of the past 15 years between the federal and Ontario privacy regulators' offices, leading work on a variety of files from online reputation to private sector law reform. So we're going to have a bit of a fireside chat now with David and Vance. And please feel free to put your questions in the Q&A, and we will have time kind of throughout and at the end to answer some questions. But let's start off hearing from them on some strategies for aligning with regulatory expectations in cybersecurity practices. David, I'm going to start with you. What are some tips for keeping privacy regulators happy when it comes to cybersecurity matters?
Okay, so thanks, Elise. Good to see you, Vance. Vance and I used to work together. Not anymore, but yeah, it's great to be here. So yeah, just quickly, I wanted to introduce just a few points on this, tips for keeping privacy commissioners happy, to introduce a few ideas that Vance and I are going to elaborate on sort of later on in the program. So the first one, I'm just going to jump in on this one, a breach response plan. Probably won't be surprising to people that the commissioners have kind of repeatedly said, organizations, no matter if you're public sector, private sector, health sector, you have to have a privacy breach response plan. The Ontario IPC calls it a privacy breach protocol. So whatever you call it, it has to be a document that contains a few essential elements in how to manage a privacy breach, which we know these things do happen with alarming regularity, I'll put it that way. So, the key elements would be, of course, containing the breach, investigating the breach, notifying the IPC and individuals, reducing the risk of future breaches. Those are the kind of the big picture elements that have a lot underneath each of them. Again, we're going to elaborate a little bit. And another piece on that I'll mention is the plan should identify team members, response members, and they could be from your legal department, from your communications department, your IT department. So that's a key element of any breach response plan. There's lots of materials out there, precedents, these kinds of things to guide you on how to create a breach response plan, or maybe you have one and you think, oh, this it's getting old, maybe it's dated, we need to have another look at it. So again, guidance from the commissioner, which we're going to talk about lots of guidance on creating a breach response plan. Speaking of notice to the commissioner, early notice to the commissioner is something that organizations don't always, meet the expectations of commissioners. They want to be notified of a breach early, but there's a tension there. And I've had clients who say, well, we're not ready yet. We don't want to go to the commissioner just yet because, we're still learning about the breach. We're still investigating. And that's great that you're still doing that. But the commissioners say over and over, come to us, notify us of the breach. And we're talking about significant breaches, right? Not every breach, but significant breaches, those that meet the threshold, the usual threshold of real risk of significant harm. Notify the commissioner early. Don't wait weeks or months because the commissioners will complain about that. They'll grumble about it. An example of that is Life Labs 2020 investigation by the Ontario IPC and the BC IPC, where they said in their investigation report that the organization waited too long to notify the breach. So the commissioners say, look, we're fine. If you don't know everything, we understand that. It's an evolving thing, but we want to know early on, often so that and this is the commissioners speaking, we can help you. We can give you some guidance on what to do and how to handle these very sensitive situations. Another tip, avoiding unnecessary privilege claims. That's a big thorny issue that we can talk about a little more. Privilege claims around, you've consulted with your lawyer about a breach. There are some tensions there, again, where the commissioner will say, I want some relevant documents. And the organization says, well, we can't give you, we have a lot of documents we can't give you because they're privileged. And to the extent they contain like pure facts, for example, that privilege claim is probably not going to be upheld. And again, back to the Life Labs case, there was kind of a big conflict there between the Ontario IPC and Life Labs about what was privileged or not. And the IPC had to make an order to disclose certain documents. Finally, I'll stop talking in 30 seconds. Know the commissioner's guidance. All the commissioners issued guidance on cybersecurity and other privacy matters. We're going to elaborate on that. Knowing the guidance is really, really important because it gives you a lot of insight into what the commissioners are thinking, how they interpret the act, what standards they're expecting in terms of privacy protection and cyber readiness, all of that. So I'm going to turn it over to Vance.
Okay. Yeah, I guess the only thing I would really build on a little bit is, I think that the next step to keeping regulators happy is actually operationalizing a lot of the policies that are being put in place. So I feel like that's where we see a lot of breaches happen. A lot of organizations kind of end up falling down a little bit. Is you have a breach plan, you've developed a breach plan, but it's never actually been tested, even as part of a tabletop exercise or something like that. So you don't actually know if it's going to function. Same as a lot of internal controls that are never monitored, never appropriately audited to make sure that they're actually doing what they're supposed to be doing. So having those kind of pieces, having appropriate staff training so that everybody in the organization does know what their actual role within these cybersecurity plans is going to be a critical piece. Having appropriate contracts in place so that the partners that you're sharing data, that you may be sharing data with, know what their role in the cybersecurity plan is. Like those are the things that we're having the actual plan is becoming kind of table stakes to a certain extent of like that's something that you have to do. What the next kind of emerging expectation is do you know, can you show the regulator that you have reason to believe that plan and the measures associated with it are actually effective? Yeah, that's kind of something I really will build on David's for that question.
Well, thank you both. I'm gonna move on to the next question. Hold on. My slides are frozen. Hold on. There we go. So Vance, we'll start with you on this one. What are some examples of helpful guidelines from regulators and why are these important?
Sure. So David kind of talked about why they're important. So I won't go too far into that. It really is though, the best. Yeah, we'll call it the best way to kind of understand understand the thought process or the thought process and the expectations that regulators actually have. I hesitated saying the best because the other way to know that is something we'll be talking about a little bit in a moment. Just the reports of findings that are issued, which kind of really walk you through effectively how those guidelines are being applied in a lot of cases. But you can kind of find, so regulators have, I kind of go back to, there is a 2017 paper from the Center for Information Policy Leadership called Regulating for Results that every Canadian privacy regulator read and kind of took into, like really took into account. And some of the key principles from that paper really saying regulators need to be helpful. They need to develop good relationships with organizations and effectively find ways to help organizations to actually comply and meet expectations. So you can kind of see that with the regulators in the cybersecurity space. They will kind of take one of two approaches. One, they may kind of take a bit of a niche issue. So if they're seeing that there are issues with, things along the lines of, virtual healthcare visits, or, just during pandemic, a lot of just video conferencing services and things along those lines. Ontario has, dedicated guidance about what the security expectations for those pieces are. So again, that's something to keep an eye on. Like look for those kind of tailored guidelines that are coming out, because that's actually a signal that the regulator sees that there's a problem there that they're trying to address, and therefore you might actually be subject of more of an investigation if something goes wrong. But beyond that, they also kind of have the broader pieces of the things that are going to happen more frequently. So certainly the federal office has detailed guidance around what you need to know about mandatory breach reporting. So that'll walk you through, effectively expecting you're going to have a breach at some point. That'll walk you through the measures of how do I understand if this is a real risk of significant harm, which is pieces of, what does sensitivity of the data mean? What is the risk of misuse of the data mean? How is the regulator going to apply that? And therefore, how should organizations apply that? So those kind of step-by-step pieces are something you'll find on regulators' sites as well. I'll kind of pass over to David for a few more examples.
Yeah, thanks, Vance. Yeah, absolutely, totally agree. I'll just add a couple of comments. One is, I know that from being on the inside, Vance, too, in the commissioner's office, there's great emphasis put on accessibility in plain language. So that this is what I like about these guidance documents, is that generally speaking, you don't have to be a super expert or be a sophisticated privacy lawyer to understand. Like they're written in an accessible manner. That's my experience. Whether it's Federal Privacy Commissioner, Ontario, BC, I have an example from BC called the BC IPC Privacy Breach Checklist for Private Organizations. Just came out last year. It's a nifty little document that's kind of like a workbook. Like it says, okay, let's walk through this breach. Here's all the questions. How many people were affected? What kind of data is it? And getting into sensitivity, which Vance mentioned. It's not always easy to know what's sensitive. There's no clear definition of, sensitive information is this. Like, it's a little bit tricky and in the eye of the beholder. What is sensitive or not? But these guidances can really help you. Yeah, as Vance says, together with decisions and reports that the offices issue. But looking at these guidance documents will give you a lot of insight. Again, they're accessible, and they can be that sort of very broad. Like there's a few that are about, how to deal with a privacy breach, and others are very specific. Like Vance mentioned, the virtual healthcare. There's not Ontario IPC guidance on that. The federal office has 10 tips for businesses using mobile apps. So again, very specific to those kinds of devices or that kind of technology. Yeah, so have a look, and they'll regularly update, and often they'll have 3, 4, 5 guidances in a year, depending on the size of the office. And again, across Canada, BC, Alberta are the bigger ones. Of course, the federal, Ontario tend to produce the most guidance documents, like what we're talking about. But even other offices will occasionally weigh in with their own. And it's really good to have a look, even outside your own jurisdiction, because there could be something really helpful from some other jurisdiction that maybe you don't normally look at. So,
and one thing I'll just kind of add on as well, it's like kind of the nature of some of these guidelines. Again, part of the why is this important. It's not just understanding what the regulators are thinking, but it's also, I mean, within privacy law, security requirements tend to be quite broadly drafted. I mean, the requirement tends to be something along the lines of having appropriate safeguards for the sensitivity of the data, give or take. It's something along those lines in any legislation in Canada, and so because that becomes a very challenging thing to interpret. Again, that said, and this is kind of coming up in the chat and Q&A a little bit. What the offices tend to be doing are flagging like what the pieces that are under our control, the pieces of kind of saying, okay, what is breach notification? What does breach notification particularly mean? Or what are some of the broad ideas around safeguards? What we are not producing are things like NIST standards or ISO standards. Generally speaking, while it's not stated in these guidelines, there is a bit of a mutual recognition, I think, within investigative processes and things like that of, if an organization can actually come and say, here are the NIST guidelines on cybersecurity. Here's how we actually met them. That's why we think our safeguards are appropriate for the purpose. There's kind of that understanding, and we as regulators don't feel like we need to reinvent the wheel and try to develop these hyper detailed like NIST level standards. So you're kind of looking, you would be looking to us for what does legal compliance mean, and then probably if you need to get more detailed into the actual practical application of step by step, what do you have to do for cybersecurity? It's probably another organization, but they inform each other.
Great, thank you. And
just very quickly
sure.
comment. Well, a couple of things. One, somebody's asked about the BC IPC privacy breach checklist for private organizations. I can send a link. But if you Google BC IPC privacy breach checklist, you'll get it in 2 seconds, I'm sure. So yeah, that is really good. One more thing that came to my mind when Vance was talking is, I think sometimes there's a misunderstanding around consistency among regulators. And I think Vance would agree with me that all the commissioners for sure in Canada, well, they meet annually, and actually more than annually now. They prioritize consistency. They tend to view things the exact same way. So it's not like you have to say, oh, well, in BC, the standard is different. It's usually not. It's usually really exactly the same. So there's a lot of consistency there. And I think people fear that, well, maybe it's not. What if there are there's 5 different levels of standards of what are appropriate measures to protect privacy and security? Well, it's not really that way. So, okay, so I'll leave it there. We can go to the next question.
Yeah, just to jump in about the guidance documents, we are going to circulate a list of resources after the webinar. So that will have links to these documents that both Vance and David are mentioning. So you can make notes and find them yourself, but we are going to provide a resource list afterwards. So stay tuned for that. Right. And I just noticed there's a couple of questions that have come up in the chat. So I can read those out before we move on. So the first question is, wouldn't NIST SP 800-53 provide direction on how to classify data?
Again, I would kind of go with, it's not necessarily going to fully align with how the regulators interpret, particularly this idea of sensitivity. It may play into like the evaluation of real risk of significant harm. And if you are pointing to that tool as this is how we are classifying our data, that's great. There is a second element to real risk of significant harm, which is around the risk of misuse of data that's been breached. That does kind of come into play around with in association with sensitivity and data classification. But again, all that to kind of say, it would be a way to undertake a classification exercise like that, but it's not the only way, and it's not an explicitly recognized way for Canadian regulators. So again, it would be at least worthwhile to kind of do a bit of that crosswalk of, regulators are putting out detailed guidance of what they expect to see, or of how they would analyze sensitive data. Let's make sure that our process under 853 aligns with what they are, what they're saying.
And just one more question. So who is responsible for enforcing that organizations follow through with their obligations, especially those outlined in something like a collective bargaining agreement?
Well, it really starts with the commissioners. And if you're talking about, private sector privacy, then, you've got the federal commissioner, and you've got the commissioners in BC, Alberta, and Quebec, who are going to have responsibility for enforcing, any non-compliance with the privacy legislation. Interesting. You talk about collective bargaining agreement, and yeah, there can be privacy obligations on employers and collective bargaining agreements. And we have seen from time to time, like in the labor relations realm, where there's a privacy problem, a privacy matter that is perhaps covered by the collective agreement, and then the labor relations regime, whether it's an arbitrator or the courts or something like that, can bring in enforcement. If we're talking about employee privacy is really tricky because there are all kinds of gaps when it comes to employee privacy in Canada. There's very little coverage. There's no coverage in Ontario. PIPEDA covers federally regulated entities and their employees, but largely employee privacy is kind of outside most privacy legislation in Canada.
Okay, thank you both. All right, let's move on to our next question. So David, we'll start with you on this one. What are some recent notable commissioner decisions relating to cybersecurity that the group should be aware of?
Okay, I have a few. I'm mindful of the time, so I'm going to be sort of quickly running through a handful here. So I was looking, just for kind of recent decisions in the last year or two. Bunch of decisions on cybersecurity coming out of the Ontario IPC and under their PHIPA health privacy legislation. So some, I guess, good instructive examples like this PHIPA, what's called PHIPA Decision 205. These are all available online on CanLII or the commissioner's website, where a phishing email was sent out from someone who appeared to be known to staff, but it was actually fake. It was sent to 200 staff. It was a successful phishing attack, and the malicious actor got access to a staff person's email account and PHI of hundreds of patients, unfortunately. And the IPC was alerted to the breach, did an investigation, and found that the custodian actually took reasonable steps to protect the breach. So it's quite interesting that, here's an example of an organization being the victim of a sophisticated breach. It's hard to have perfect prevention and security. This is an example of, they were fooled by, again, a very clever attack, I guess you could say. And so, and the IPC said, well, as they do, let's have a look. What were your breach protocols? All of that. What measures did you take to prevent these kinds of breaches, including training? And the IPC said, well, I think the organization took reasonable steps to prevent the breach. So there was no, violation of that health privacy law. But then the commissioner went on and made all kinds of recommendations about what the organization might do to enhance its security and try to prevent an incident like that from occurring again. We have another decision, again, Ontario IPC Health Privacy PHIPAA decision 210, also from 2023. The hospital, in this case, it was a hospital, was victim of a password brute force attack. Attackers got into the account of a person who had privileged access. This person exfiltrated data, but it was not clear what data. And sometimes that can be a problem where data was exfiltrated, but there's no ability to determine precisely what data that was. But it was apparent that hospital patients' records were disclosed. The hospital notified the patients of the breach, offered these individual patients to monitor the dark web for their data for 2 years, which is kind of a common response, or I guess measure to give some relief to the victims of the attack. And the IPC said, well, the hospital took appropriate steps to respond to the breach. They acted responsibly. Obviously, they had a good plan in place and they followed it. One of the things that the IPC recommended here, among others, was what Vance talked about earlier, a simulated breach exercise or tabletop exercise, which I think are, in my experience, are really, really useful because a whole lot of gaps can emerge from that, and you can really learn a lot from that kind of exercise. So I think pretty important. Another one, again, IPC PHIPAA decision 184 from 2022. This one's actually a little bit humorous. It was kind of a textbook case of what not to do. This was a clinic where staff were sharing passwords with one another. They were taping passwords onto the wall. They were using a kind of ridiculously outdated devices and software, and they had incomplete security patching. So there was a number of very serious shortcomings in protecting privacy and cybersecurity. And not surprisingly, the IPC said here, well, clinic, you did not have reasonable measures in place to prevent disclosure because there was a breach. So that's a good example to look at. And finally, I know, because we're trying not to take up too much time here, this is a big one. Now we're finally moving out of Ontario into Newfoundland. Huge breach in Newfoundland of the Provincial Health Authority, which is a gigantic organization that has health data of many thousands of residents of Newfoundland. And in fact, it was considered, the Newfoundland IPC investigated and determined that it was the largest ever cyber attack and ransomware attack in Newfoundland. That was in 2021. Very complex, wide-ranging investigation, took quite a long time. I think well over a year, a couple of years. I think the IPC found that there were many weaknesses in cybersecurity at this organization. It's a large organization, right? That's well funded and all of that. What was really interesting to me in this case was the department itself was specifically warned 1 year prior to the successful attack that it was at high risk of being attacked. And it really did not adequately respond to that. The IPC also found that after the event, the organization's notification efforts were very slow. They were incomplete. And this authority was not fully forthcoming with the commissioner. Another problem where you see this kind of behavior where it's like, well, we don't really want to tell you everything. We'll tell you what, we feel like sharing with you, but not everything. Commissioner was expressed unhappiness with that. So I'm going to end this piece by reading a quote from the commissioner because I think it's really good. So here it is. Cybersecurity is and will continue to be an ongoing arms race with organized crime, as well as state-sanctioned actors who will not only attempt to extort us and breach our privacy, but also cause us to incur significant costs and harm actual healthcare delivery and other public services and critical infrastructure, potentially putting lives at risk. It's nothing less than a matter of national security and needs to be treated as such going forward. So I think a really well-worded kind of encapsulation of the seriousness of the cybersecurity problem that we face in this country. So over to you, Vance.
Yeah, so again, in the interest of time, and because we're sharing the links, I won't go deep into some of the federal investigations. And so just to name them so you can kind of recognize them. I've seen MGM suffer giant breaches. Seen Mary have major breaches. Even smaller groups like there's an interesting case study of something called Agronomy, which kind of operated a series of smaller stores called Agromarts. Anyway, just to kind of go high level and kind of extract the trends to kind of deal with this quickly. Again, I think as you're kind of seeing from David, I think what we're really still seeing is breaches that are frequently end up kind of being caused by or one of the initial factors is something like passwords, is something like credential stuffing. It's either credential stuffing or some other kind of a phishing attack to gain access to credentials, paired with failures of multi-factor authentication. So that's something that's popping up more frequently. Is that again it's that testing, it's the penetration testing and things along those lines to kind of say, great, we have multi-factor authentication. Is it useful? Like, is it doing what we think it is? And then once the person's inside the organization, we're still running into the problem of data not being segregated, or there being too much possibility of lateral movement amongst across various systems. So again, we keep running into the thing that, I mean, all cybersecurity people know, it's kind of like one breached system really shouldn't lead to the breach of the entirety of an organization's networks. Yeah, so again, that's high level. That's I guess what we're kind of pulling out a lot of the findings. Is again, like the entries generally aren't that challenging. It's purely somebody got access to credentials and then were able to escalate themselves up to an admin and move across systems and exfiltrate data. It keeps happening over and over again, and that's the frustrating piece that when regulators are seeing it, it's like, when we're having these trends, when we're having these issues that keep popping up, those are the ones where it's kind of like, maybe we don't give quite as much leeway as, this was a 0-day attack that nobody saw coming. So that's the summary I'll kind of give of some of the findings that have been coming up recently.
Great, thank you. I see a number of questions coming in, so hopefully we'll leave some time at the end, and we'll keep going with our prepared questions for now. But so just jumping to our next question. Vance, can you share your thoughts on the recent Ontario IPC decision on the use of artificial intelligence?
Sure. So I'm kind of going to leave the thoughts piece to David a little bit. What I'll do is like give the summary of kind of what we're talking about here. So when we're talking about this IPC artificial intelligence finding, it relates to a case a couple of years ago. It's a pandemic related case in which a university started using proctoring software to invigilate exams online. The proctoring software kind of had two components to it. One was called Monitor. One was Lockdown Browser, which did what you would expect it to do. It fundamentally kind of said, when you're taking this exam, fundamentally nothing else on your computer is accessible. It kind of stops the ability to open browsers or to access notes or basically to do anything but be on the page showing the exam. And then where the AI piece kind of came in was in this system called Monitor. The broader company being used called Respondus. So this is Respondus Monitor. And what Monitor did was effectively intake video from the webcam of whatever camera or whatever computer is being used to take the exam, and examined it for potential signs of cheating. And there were students who kind of raised or complained about the appropriateness of that process, and that complaints about the complaints about the notice, and complaints about the amount of information that's being collected, and questions about how that data, how those videos were being used outside of the context of outside of the context of exam invigilation. So what the IPC did was had to basically go through an interesting process of determining of considering necessity for using those processes. Because for those who aren't familiar, whereas private sector law and federal private sector law tends to be a consent-based law, where an individual is agreeing to a process, or they are or there's an exception of why you can use their personal information. Under public sector law, that tends to be switched to, I fundamentally just call it a necessity process. So is data being used for something that the organization is mandated to do, and is it necessary to use it for that purpose? So again, I'll let David highlight some of the takeaways, but if you're not familiar with public sector law, it's an interesting read to kind of really get through to understand how that analysis works. And I think it's going to be particularly useful for this kind of a group, just because AI is already a key part of a cybersecurity defense platform, and the more it becomes kind of almost the central piece of cybersecurity, there may be more of those questions start popping up in the context, certainly, of public sector uses of these systems. Of what is the necessity is the necessity test actually met? So again, the more you're starting to work with public sector or sell into public sector, this is going to be something to look at, something to read through. But anyway, I'll pass it to David for some of the key takeaways the IPC actually found.
Yeah, thanks, Vance. So yeah, this case is called McMaster University. Bottom line, Vance explained it very well, but I'll just add the bottom line here was the IPC said the university's use of the software was acceptable and recognized that it's an important tool to ensure the integrity of the exam process. But Commissioner made a number of recommendations that I think are interesting and kind of highlight where the tensions are. One, IPC said to McMaster, you have to be more transparent about the use of this kind of software. And I think that's maybe what's at the root of the problem. You got to give a better notice so that students understand how the system works, basically, what information it collects. So be transparent with the people, whose information you're collecting, including biometric information. So that's a big one. Commissioner said, well, I'm not really happy with your contract with your provider for this software because and it could be improved to better protect students' personal information. So that's a big one. Contractual measures to protect privacy. They should have allowed the students to opt out. So somebody can say, well, I don't really want to subject myself to this AI. Can I get a real human to invigilate here? So again, it's sort of empowering individuals and letting them, this fundamental of principle of privacy law, let people make their own decisions about what happens to their personal information. And lastly, and probably most importantly, when it comes to AI, the commissioner recommended an algorithmic impact assessment, which is a generally important point for any use of AI, particularly that impacts privacy. Do an algorithmic impact assessment to identify the risks and ensure that this kind of AI is safe, privacy protective, transparent, accountable, consistent with human rights principles, all of that. So, yeah, so really interesting case to read. Highly recommend it. We'll give you the link.
Great.
Lisa, over to you.
Thanks, David. So I know we're running out of time, so why don't we quickly, if you can both speak to what everyone should be looking out for in the next year or so with respect to cybersecurity law. Maybe we'll spend sort of 5 minutes on this and then answer some of the audience questions. But I know it's a big question in 5 minutes. David,
no, we'll be quick. We'll be quick. And basically what it comes down to is two hugely impactful federal bills that are in the works, Bill C-26 and Bill C-27. I'm going to talk about C-26. It's the proposed Critical Cyber Systems Protection Act. It's in second reading right now. Somebody was asking what's happening with the bill. It got second reading. It's in committee now. We don't know when or if it's going to pass. Anyway, let me just give you kind of the key takeaways on this bill. It imposes cybersecurity duties on private companies in 4 key federal sectors: telecommunications, finance, energy, transportation. It aims to protect vital systems and services, which are, back to telecommunications, cross-Canada pipelines and power lines, nuclear power generation, federal transportation, and banking. So there are 5 key cyber duties. 1, implement a cyber program, which we talked about. Identify risks and take steps to mitigate. 3, report any incidents to the Canadian Security Establishment, CSE, and to whatever your industry regulator is. For example, if you're a bank, report to your banking regulators. Comply with any directions from cabinet. And lastly, number 5, keep records of your cybersecurity program and of any incidents. So record keeping is a important part of it. As far as enforcement, it'll be enforced through administrative monetary penalties up to 15 million for organizations, excuse me, and 1 million for individual directors or officers. That's the cap. And there are also potential criminal fines and even imprisonment. So pretty tough piece of legislation that looks like is going to be on the way, but who knows what's going to happen. Vance, over to you for C27.
Sure. I mean, and so C27 would be it would be a few things. I mean, fundamentally, it's the update to the Personal Information Protection Electronic Documents Act, or PIPEDA, and it would potentially, for now, introduce the Artificial Intelligence and Data Act. We'll see if that sticks around or not. Not massive changes related to cybersecurity. It's still kind of going to be fairly high level. So, I don't think C27 is going to have a huge impact on cybersecurity, with the possible exception of if ADA goes through, in which case, there would be a lot more. You start to see a lot more requirements around on the use of data for for artificial intelligence, even if it's not personal information, which would fall under the CBBA. The other thing I want to kind of just quickly flag, because I like to flag it. It's not necessarily a next year development, but we'll see. Is there's a bill that's almost passed, and it should be passed soon in the EU, called the Cyber Resilience Act, which I kind of think could have a similar impact to what we saw with the GDPR. So GDPR really has kind of influenced privacy law globally. I think Cyber Resilience Act could have a similar impact on cybersecurity. So where, the EU has a Cybersecurity Act, which is similar to what we're seeing in C26. They have a Cyber Resilience Act, which is fundamentally kind of saying any device that has as one of its significant functions communication with the internet. So fundamentally, the entirety of the Internet of Things will be required to meet defined cybersecurity standards, and those standards will vary by industry. And there's a lot of kind of work to do about what those standards actually are. But that could be a real first step towards kind of saying, cybersecurity isn't just about networks. It's not just about organizations. It's going to have to be designed into consumer level products. So again, that is received agreement amongst various parties in the EU. It's not 100%, not quite passed. It might pass in the next months. So again, take a look at that act. Keep an eye on it and see what the impacts may be over the next handful of years. And I'll stop there.
Great, thank you both. So we do have some time for some questions. I see there's a few here in the Q&A and chat, so I'll read out the first one. What is the largest fine that has been issued to either a private or public company in Canada to date, and what was the material reason for it? I don't know if you can.
No, so I mean, I guess I kind of say that's one of the fundamental challenges and one of the fights that's happening right now in Canada is that, with the exception of Quebec's new bill or Quebec's new updated privacy law, privacy commissioners just fundamentally don't have fining power. In a lot of cases, they don't even have order making power. So that's kind of been there has been. I mean, I always hate giving this answer. Fundamentally, the answer is there haven't been fines. Yeah, it's not something we see in Canada, but it's something that we may start to see with the new batch of privacy laws that are being introduced and kind of going through.
Thanks, Vance. So next question, any opinion on the impact of AI on Indigenous data sovereignty, specifically in relation to AFN's briefing regarding Bill C-27?
So there's not a great update I can give. I can kind of say that's something that's being brought up a lot before committee on that's studying C27. Again, there are, even just yesterday, there was a group of about 60 civil society organizations that called on the government to split ADA from C27. And one of the reasons that was highlighted was the fact that there was no consultation done with First Nations to examine the impact of that bill, and I suspect there is some openness to reconsidering the approach on that bill, or there's openness within not the Liberals. So we'll see what happens with that bill. I think it would. I mean, obviously there would be a pretty significant impact on Indigenous data sovereignty, and that may be one of the reasons why that bill ends up getting reconsidered.
Great, thank you. So the next question, are there any interesting developments that are in the pipeline from the federal government in relation to data residency, GDPR, basically something like the US Privacy Shield for Canada?
So I had seen that question. Sorry, David, I don't know why I keep jumping in.
Oh, that's okay.
Feel free,
No,
but
your questions.
I would kind of say, so I mean, first I'll kind of mention that the EU did renew our adequacy finding within the last month or so. So it's Canada for data that's covered by PIPEDA. Canada is still considered adequate when it comes to the EU. That is even without having some kind of an agreement with respect to how data is possibly flowing through to the United States. So at the moment, it's kind of not being seen as something to do much additional work with. There aren't, with certain exceptions, there aren't data residency requirements established by most Canadian privacy laws. There's a couple. I think Nova Scotia has a limited data residency requirement for government. Quebec's Bill Law 25 has its whole own, like it's got some odd data residency pieces, but that's a whole other topic. But yeah,
sorry, Vance, I don't want to cut you off.
Yeah,
I'm just
sorry.
been told we have a hard stop at 3.
Yeah.
So I understand we will be taking note of the other questions that we didn't get to, and we will try to follow up with answers to those. But I just want to thank everyone so much for joining us. Thank you so much, David and Vance, for participating today, and to our partners, Canadian Cybersecurity Network, for giving us this platform to hold this webinar. I've included some contact information on the screen. If you have questions about our programs, please reach out. And we really appreciate everyone being here today. Thank you for all the questions in the chat. We'll try to get to the rest. Thanks, everyone.
Thank you.